Over the past 2+ years, the Fair Political Practices Commission, or FPPC, has completely overhauled the regulations that interpret and apply the Political Reform Act's conflict of interest provisions. For those of us who follow the FPPC or who care about government ethics, this is huge. In practice, these changes should be important to public officials, public employees, and public agencies, as well as the public, private, and nonprofit entities that may have matters pending before local or state governments. The big picture rule of the Political Reform Act's conflict of interest provisions prohibit a public official from gaining financially from their public service. This means that they can't take actions that will foreseeably impact sources of income, real property, business entities with which they're involved, or their own pocketbook. The FPPC's recent work has changed how we analyze and guard against potential conflicts and the appearance of divided loyalties. We used to have a complicated 8-step process. Now, once we determine if a public official, employee, or consultant is covered by the regulations, and whether the individual has a financial interest under the law, which could be a source of income to the official or his or her spouse, real property, or more, we walk through a simplified 4-step analysis and reordered, revised regulations. Once we know that we have an official with a financial interest at play, the first step is all about likelihoods. That means, can we envision it happening without it being hypothetical or theoretical? If it's not reasonably foreseeable, we stop there. If a financial effect is reasonably foreseeable, we have to look at whether it's important enough to matter. These are the materiality regulations. The materiality regulations tell us, is this a big deal? Is the effect big enough to guard against any sort of improper influence? Here, the regulations have gone from multiple pages to just a few, so we can now figure out materiality much more simply. Once we know if an effect is reasonably foreseeable and going to be material, we need to know if it's going to be the same for everyone. Is this the sort of decision that's going to affect everyone's interest in a substantially similar fashion? If we've gotten through those first 3 steps, we're on to the last step. That step is the prohibition itself. If we have a public official who's got a financial interest that will reasonably, foreseeably be affected in a material fashion and in a way that's different from everyone else, that person cannot be involved in the making of a government decision. So they can't vote, they can't suggest, they can't make referrals, they can't even wait. So here we have the end game. If we have a prohibition and the person participates anyway, they break the law. Last but not least, it's important to remember that the Political Reform Act's conflict of interest provisions are not the only legal guard against improper influence. So if anything you've heard on this video today makes you think that possibly you or someone you know is about to be involved in the making of a decision that presents a potential conflict, even that looks like a conflict, please ask for help. As with most laws, there are some limited exceptions. Please consult an attorney if you think one might apply to you.